Welcome to another mind-expanding and unrelentingly exciting video training session, this time on clinical record keeping and confidentiality in practice. My aim in putting this together was to be as brief, accurate and informative as possible, so I pared it down to the bare bones, and once it's over and you pretended you've given it your full and undivided attention, we'll have a discussion and a Q&A to explore further and clarify any issues arising. So let's jump right in. Clinical record keeping is considered to be an integral part of professional practice. It's felt that accurate and effective record keeping is fundamental to high-quality patient care, enables effective communication with other professionals, and that health records act as an information base for health professionals and as a medical legal record of the care provided. As to the question of what is a clinical record, the effective definition is anything that contains information in any media which has been created or gathered as a result of any aspect of the work of healthcare employees in relation to patient care and treatment. It may contain information about the current episode of care only, or maybe a compilation of every episode of care for that individual. Whatever is written or recorded is considered a legal document and may be used in a court of law. Clinical records are important from an organizational perspective because they can enhance individual practitioners and the organization's liability against negligence claims, including indemnity for damages and costs, general medical counsel proceedings, local health board inquiries, disciplinary proceedings relating to alleged professional misconduct or incompetence, inquests, complaints, criminal matters arising from professional practice. And it's important for the patient because good quality clinical record keeping is felt to protect patient welfare by promoting high standards of clinical care, continuity of care, better communication and dissemination of information between members of the multidisciplinary healthcare team. It provides an accurate account of treatment and care planning and delivery, the ability to detect problems such as changes in the patient's condition at an early stage, and recognition of the patient's wishes and consent to treatment. The NMC insists that the quality of record keeping is a reflection of the standard of professional practice, an indication of a skilled and safe practitioner, and fundamental to good risk management practice. The NMC also feels that certain patients require documentation to be completed more frequently on their behalf. These are defined as those who present with complex problems, show deviation from the norm, are vulnerable or at risk of harm or abuse, require more intensive care than normal, are confused and disorientated or generally give cause for concern. I think what they mean is document more frequently with regard to patients generally. The key purposes of the clinical record are to act as a working document for day-to-day recording of patient care, to store a chronological account of the patient's life, illness, its context and who did what and to what effect, to enable the clinician to communicate with him or herself, to aid communication between team members, to enhance continuity of approach in a continuing illness, to record special factors affecting patient care, to record risk assessments, to record advice given to GPs, carers or others. Clinical records should be accurate, factual, consistent, clear, recorded as soon as possible, consecutive, involving service users whenever possible, readable when photocopied or scanned, and avoiding of jargon, meaningless phrases, irrelevant speculation, offensive or subjective statements. Registered clinicians have both a professional and legal duty of care. Their record keeping should therefore be able to demonstrate the following: a full account of patient assessment and the care that has been planned and provided, relevant information about the condition of the patient at any given time, the measures taken to respond to patients' needs, evidence that the clinician has understood and honoured their duty of care, that all reasonable steps have been taken to care for the patient, that any actions or omissions on the part of the clinician or others have not compromised their safety in any way, a record of any arrangements that have been made for the continuing care of the patient. The perspective of the courts is one that can be open to discussion and debate in another forum, but it is simply this black and white principle. If it has not been recorded, it has not been done. Multiple healthcare organizations do not have one definitive process or pro forma for the recording and storage of clinical records. However, there are a set of general standards that support good consistent practice, and they are as follows. Documentation should clearly identify the patient by name and identification number or date of birth if ID number not available on each page of the record. Identify the patient's ethnicity. Record each patient contact, either direct or indirect. Be factual, consistent, and accurate. Be written as soon as possible after an event has occurred, providing current information on the care and condition of the patient. Records should be written clearly and legibly and in such a manner that the text cannot be erased. Records should have the date of contact recorded. Record the time of entry into the patient's records using the 24-hour clock. Be signed with a signature printed alongside the first entry together with professional status. Be written in permanent black ink. Not include jargon, meaningless phrases, irrelevant speculation, and offensive subjective statements. Any alteration should be scored through with a single line, dated, timed using the 24-hour clock, and initialed in such a way that the original entry can still be read clearly, and a note made in the margin that the entry was made in error. A line should be drawn through any empty space at the end of an entry. Correction fluid, for example Tipp-Ex or highlighter pen, must not be used in patient records. Legible instructions and a rationale for all treatments, therapies and medications should be included. Before commenting on subjectivity versus objectivity, I feel some mention should be made with regards to the requirement for good basic grammar and spelling and legible documentation. They are essential for accurate written communication, I'm afraid. Grammatical errors or misspellings have the potential to give a wholly erroneous picture in certain cases, as is illegible writing. And this is especially where drugs, therapies, treatments, frequencies, names, etc. are involved. Giving due care and attention to these elements is strongly advised. Subjectivity versus objectivity. What do these statements really mean? Satisfactory, good, poor, normal, abnormal, confused, depressed, large, small amount, large amount, well, unwell, overweight, underweight, observe, wait and see, PRN, frequently? In isolation, these statements are either meaningless or open to inaccurate interpretation. Qualify and quantify such statements with measures, observations, and descriptions of appearance and behavior. Organizationally, the issue of confidentiality relating to patient information in health and social care is underpinned and supported by the Caldecott principles. These were originally developed from a review in 1997 into how the NHS handled patient information. Principle 1. The practitioner needs to be able to justify the purposes for using confidential information. Principle 2. Use confidential information only when it is necessary. Principle 3. Use the minimum necessary confidential information. Principle 4. Access to confidential information should be on a strict need-to-know basis. Principle 5. Everyone with access to confidential information should be aware of their responsibilities. Principle 6. Comply with the law. Principle 7. The duty to share information for individual care is as important as the duty to protect patient confidentiality. Principle 8. Inform patients and service users about how their confidential information is used. In order to understand confidentiality, we need to know that confidentiality is about information. It's about information that is kept in a state of secrecy. We all entrust information to people or organizations who we trust and have confidence in to keep our information secret and private. For instance, healthcare professionals, hospitals, banks, building societies, local government, social services, utility companies. And of course individuals whom we might meet socially or at work, friends, colleagues. In certain cases, confidentiality is assumed, felt to be a given thing. At the GP surgery or in hospital or at the bank, we quite rightly assume that our personal details will remain confidential. Socially, we do not automatically assume the same level of confidentiality. In social circumstances, we might confide information to a friend or acquaintance and add something like, "This is just between you and me," or "Please keep this to yourself," or equivalent. This is so we are clear to others about how how we want the information we have imparted to be managed. Socially, although there is perhaps a moral imperative to keep information confidential as requested, there is no legal precedent such as there is in healthcare, for instance, where patient confidentiality is a legal requirement. Professional people and organizations dealing with the general public usually have a legal obligation to keep information regarding individuals confidential. Organizations and businesses have a legal and professional obligation to keep personal information about their employees confidential. Where confidentiality is breached or not upheld to an acceptable standard, professionals and organizations can face legal and/or disciplinary action. Confidentiality guidelines. All healthcare organizations will need to have access to a wide range of data about their patients. Clinicians and others may have access to information on patients whilst in the course of their work. This may include information written in care plans and risk assessments, details given to you directly by patients, and information gathered from conversations you may have. All employees within Hospice of the Valleys have a duty of confidentiality to patients. They will treat all information with respect and in the best interests of the individual to whom it relates, and will maintain confidentiality when handling it. Individuals have the right to privacy and dignity. Any information needs to be handled in such a way as to cause as little intrusion as possible into this right. People need to feel able to share information, confident that it will be handled with confidentiality and respect and used only in relation to the purpose for which it was intended. Certain information comes under the heading of sensitive personal data. This would be racial or ethnic origin, political opinions, religious or other beliefs of a similar nature, membership of trade unions, physical or mental health conditions, sexual life, and the committing of any offence or criminal records. Confidentiality guidelines apply to carers, family members, and those with care needs, employees, volunteers, trustees, donors, supporters, and people from other organizations. The Data Protection Act 1998. Under the Data Protection Act of 1998, when you hold personal sensitive data, you are only allowed to use it for the purpose or purposes for which it was originally obtained. You are required to take good care of it to maintain confidentiality. You are required to use it fairly and lawfully. You are required to keep records no longer than necessary. You will be committing an offence if you gain access to personal or sensitive data you are not authorised to look at, disclose information knowingly or recklessly to people who are not authorised to see it, sell personal or sensitive data you are not entitled to. Breaching confidentiality. This can involve gossiping about patients, passing information on to others who do not have a need to know, sharing any information outside of Hospice of the Valleys, making any disclosure without the express permission of your line manager, not disposing of paper material securely, for example by shredding, leaving computer screens open or sensitive material lying around the office or other premises in open view, posting or discussing any information gained through your work on social media, engaging in any communications through social media or email unless specifically authorized through your line manager. Finally, failure to observe confidentiality may place others at risk. It may severely damage the reputation of the organization. Hospice of the Valleys will only break the general rule of confidentiality in circumstances that justify taking action in the best interests of the patient or any other person. For example, to protect a patient or any other person from grave danger. Only a designated manager can make the decision to break confidentiality, and any queries should be referred to your line manager. Lastly, there follows a short video on GDPR. GDPR stands for General Data Protection Regulation. It's an EU law that went live on May the 25th, 2018. It tightens the laws surrounding the issue of what companies and organizations can actually do with a person's personal data. It gives individuals more control over how their personal data is collected and used. It also forces companies and organizations to justify everything they do with that data. Personal data under GDPR is considered to be anything that can identify an individual. Their name, phone number, username, IP address or location data. Even tighter regulations apply to sensitive personal data, such as and including sexual orientation, health data, and political opinions. Do people have the right to be forgotten? Yes, people can request to have their data deleted. However, this is not absolute and certain conditions apply. Organizations and companies not complying with GDPR could face fines of up to 20 million euros.
Wow!
So how might GDPR affect clinicians working in healthcare in the UK? Well, they need to look after information held about patients correctly. Professional confidentiality obligations remain the same as ever. Patients have rights to see their personal information. They can make a subject access request to see the personal information held about them. Health organizations often get freedom of information requests relating to the medical records of the deceased. There are no special exemptions under the Act about the deceased, but consideration needs to be given to whether the information is sensitive. The Information Commissioner's Office website provides an extensive series of FAQs, checklists, guides, templates, toolkits, and advice in relation to rights to access, freedom of information, health sector resources, health and safety, and data breaches. GDPR affects everyone, and as such, awareness and getting it right is everyone's business.